And good morning, everyone. Welcome to our Property Management Task Force. We have a very special meeting and super excited that we have John joining us today to speak to our group. I know that there's been a lot of questions and concerns, and so because it is a smaller group, I know that you guys will be able to interact with John and hopefully get your questions answered. But before we do that, very quickly, for those that were present, I believe Debbie was there. We have Shayla, we had Krista. At our last meeting, if you could just review the minutes and if there are any questions, I did send these via email. Let me know, and if anybody wants to motion and second.
I'll move we accept the minutes from last meeting.
I'll second it.
I'll second it.
Thank you, Krista. Thank you, Shayla. Does anybody oppose? Are there any changes? I don't see any hands raised or comments. So we're going to go ahead and pass the motion, and we're going to move forward. So, John, thank you so much for joining us today.
Well, good morning,
and
everybody.
The floor is yours.
I'm gonna. Oh, there we go. Okay, I can see some of you. I can't see the rest. Good morning, Deborah. How's it going? Nice to see you.
Nice to see you, John.
So I don't know exactly how this program works, and so what I've done is Sylvia sent me a number of questions from both your last meeting and a couple of questions that came in from Ellen, and so I'll try to answer those questions as best I can. I'm going to limit my conversation today specifically to 3088, but of course, if there's anything else anybody wants to talk about, certainly I'll do the best I can to answer. On Thursday at 1:30, I'm doing a brown bag, and just so you know, I'm going to be going over something that NAR did last Friday. They passed a motion to add hate speech restrictions to your code of ethics, and it went into effect immediately upon passage by the NAR board of directors. And so, because if you violate the rule, it will be reported to the Department of Real Estate. I'm going to lead with that, but then I'm going to go over the new forms and some other stuff as well. And Sylvia told me that we're probably going to have, about 150, 200 people. So, we'll be able to answer questions as well. I'm going to try to save about a half hour of the 2 hours for questions and answers. So if I don't answer a question today, I'll answer it then. So, Sylvia, what I got from you was a series of questions that talked about 3088. So I don't know if you guys want me to go over 3088. If all of you feeling pretty comfortable with it by now, what's your pleasure? Let me know. If not, I'll go into the specific questions and try to answer them as best as I can. Anybody? Oh, you can go ahead and unmute your mics if you'd like. I'm perfectly okay with that. All right. Anyway, so one question that keeps popping up, I get it frankly, lately, almost on a daily basis, is selling your rental. What procedures under the new bill? It depends. Let me give you the basic standard procedure. Number one is you cannot evict your tenants because they didn't pay rent unless they fail to file a proper procedure. So let me make it as simple as I can. Under the rules that will stay in effect probably until February, although there's a lot of scuttlebutt that they're going to extend 3088 past February. Walter can speak to that as well as I can. You have to number one is if the tenancy is for more than month to month, you have to honor the contract. Number one. So if the contract is still in effect for another couple of months, then you have to honor that contract unless you can work out an early termination, cash for keys kind of a relationship. Number two is that under the current rules, which is different than the rent control rules, which provide for just cause or relocation fees and all that, you have to have an offer from a buyer who has indicated they intend to occupy. If you don't have an offer, or you're not planning on moving in yourself, then frankly, the eviction process is going to be gravely limited. If you have an offer from a buyer who intends to occupy, then you can give either a 30 or a 60-day notice, depending upon the circumstances, and go forward with the transaction. If the tenant fails to move out and you have a legitimate buyer, then you can avail yourself of the process that is laid out in the 1162, which is the eviction process. So evictions are still taking place. That was another question. Evictions are still taking place in some counties, Riverside being one of them, but not for unpaid rent. Again, I'm happy to answer any questions. I don't know if you guys want me to go over 3088. So the different scenarios, the notices depend upon the circumstances. There's 30, a 60, a 90. There is no, as of right now, there is no 3-day notice to pay rent or quit. It is a 15-day notice with a declaration and a number of other procedures. So that's that. Any questions about that? Bottom line is you got to have a buyer who's going to occupy if your seller wants to sell, or you're going to move in. The buyer's going to move in themselves, either them or an
I have a
immediate
question.
family member. Yeah, Candace.
Michelle or Candace?
I don't care. You got Michelle. You unmuted first, so you go first. Candace, you're next.
I have a property that the tenant stopped paying due to COVID, but the lease was for 1 year and the owners moved out because they were separating, and that's why I rented their house. Now they're reconciling and they want to move back into their home. So I gave the tenant, I mean, it was even before the COVID thing, a 60-day notice to move. No, it wasn't before the COVID thing. 60-day notice to move because the owners plan to owner occupy. And he said, you can't evict me due to COVID. So my eviction attorney has filed or has got all the paperwork, and he dropped it in the drop box at the court. But that was like a couple of months ago. He doesn't even have a case number yet.
Yeah, well, there's, when I said the courts are open for business, I didn't say they were open for business officially. Things are still pretty rough. We're still sorting out a lot of that stuff. I don't do litigation anymore, but in talking to all the litigators, they're still having trouble depending upon the courtroom. As far as the procedure, you followed the correct procedure. The clients can move back into the house upon giving the appropriate notice, so long as it's not a term of years. But getting through the court system and all that is going to be difficult. I know that a lot of the courts are starting to do trials via Zoom. Obviously, with the governor indicating yesterday that he's planning on a more aggressive shutdown, I don't know whether the courts will be allowed to stay open, whether they'll still stay open only via Zoom. That's a practical problem, and I can't answer that depending upon the court. So you may have to wait that out. But as far as the procedure is concerned, it sounds like you and your unlawful detainer attorney or eviction attorney followed the right procedures. Candace, question?
Yes, good morning. I have a tenant who's been living on my property for about 12 years. They're coming up with excuses to not pay the rent now, but she's on Social Security, so it has nothing to do with COVID. And they've moved multiple people into my home and breached all the contract. Can I evict them?
Okay, first of all, let me do a disclaimer that I'm going to be giving you information to the best of my ability based on the facts without looking at documents, et cetera, et cetera, et cetera.
Okay.
So this is not legal advice. You still, this is the lawyer's escape clause, okay? Probably not. First of all, and I want to say this to all of you, this is something I was talking to Bob Bloom from CAR, who handles a lot of the landlord-tenant stuff and writes the Q&As that you guys all get. And he's a brilliant lawyer. you got to be really careful about evicting where you're coming up with some reason other than a clear breach that is presently taking place. Okay, there was a case that came down where the tenant had pets, not companion or service animals, but legitimate pets, okay, in violation of the lease, and they had those pets there for a long time. The landlord, property manager, never did anything about it. COVID came up, stopped paying the rent, and they were using the breach of the covenant to not have pets as an excuse, and the landlord was held to have been retaliating, which is part of AB 3088. There's a whole section on retaliation. So you need to be very careful about connecting a non-rental payment breach to a present day situation. You got to be really careful that you don't dredge up something the tenant did in the past. Non-payment of rent between March 1st of 2020 and January 31st of 2021, under rare exceptions, is probably not going to be grounds for eviction, period. That doesn't mean they don't owe you the money, but you have to go get a judgment. Even if, let me give you an example. The tenant's not paying rent, but they're also in violation of another evictable, if that's the right term, condition. Under the old laws, you would go to your prove up and or your case, your trial, and you would prove up the right to possession, which is the primary grounds for an unlawful detainer. By the way, pardon me for that. That's my home phone. My wife's not home, so I apologize. She usually picks those up pretty quickly. Under the current rules, as they're written, if you go get an eviction because of because of a breach of the lease not related to payment of rent, you still can't get a judgment for the money. You've got to go separately to small claims court, or if it's over $10,000 to regular court and get a money judgment. If you wait until March 1st, unless they change the rules again, you'll be able to go to small claims court for any amount, but all you're going to get is a judgment. So in a situation where the tenant is judgment proof, you're probably never going to see that money. So that needs to be a business decision that you guys need to make as to how you go ahead and negotiate with these tenants, because at the end of the day, it becomes a case-by-case business analysis, right? If Dana, for example, has a client who's got a good job, maybe has some other assets, something like that, then a judgment maybe has value. But in a situation where the tenant is struggling month to month to even pay their food bills and their childcare and all that, then you're probably never going to see that. I had breakfast with a bankruptcy attorney on Saturday morning, and we were talking about this issue and the fact that realistically, there's a whole wave of bankruptcies going to be coming down the road probably next year. Because if I'm a tenant and I owe you for March, for the rent, and you get a big judgment against me, why? And plus I've been using my credit cards and all this other stuff. I'm going to waltz down to the bankruptcy court and file Chapter 7 and discharge all my debt. So realistically, you need to be clear and honest with your landlords and say to them, look, doing a cash for keys, forgiving rent, using some of those other forms that CAR has provided to you is probably not, while is it fair? Forget fairness. Fairness doesn't exist today. You're talking about what's best monetarily for your clients to negotiate out of the bad situation. Any other questions before I?
John, I have a question.
Yes, ma'am.
I know that two things, it's kind of a two-part thing. So if a tenant isn't paying rent, it is not COVID related, and an owner wants us to serve a 3-day notice, is it now, it's the 15-day notice with all the related COVID papers, even though it's not COVID related?
Let me answer that question and compartmentalize it. Number one, you have to look at the time. If it's between March 1st and August 31st, that's one deck. The answer is yes to the no 3-day notice. So it's a 15-day notice, not counting weekends and holidays, extra 5 days for mail, et cetera, et cetera. So it's a long notice. There's one notice from March 1st to August 31st, and a separate declaration and notice from September the 1st through and including January 31st, but keeping in mind that 25% isn't technically due until January 31st. So that's, I forgot the rest of your question, but that's clear. Oh, here's one other thing, and you guys are gonna not like this. I didn't write the statute, okay? It's 36 pages. Walter, I'm guessing you've read it. Some of the rest of you have read it. It is probably, to use Robert Bloom's comments, it was a law that was rushed into law by the legislature because the Supreme Court of California basically said, we've been giving you guys cover all this time by closing down the courts and creating a judicial moratorium. We're not doing that anymore. So she gave them until the 31st of August to come up with a bill. They took about 4 or 5 bills that Walter was monitoring along with Gino and Adam, knitted it together with some really cheap knitting and sent it out. If I'm a tenant and I sign a declaration, one of the two or both, and I say, I'm not paying you because of COVID, you are not allowed to ask for documentation, and you're not going to be able to prove at a trial that I lied. It's unbelievable to me, frankly, that's the law. But as both CAR and then I read it for myself, and I agree with their analysis that there is no remedy if I'm not a high earner. If I'm a high earner, which is somebody that makes at least $100,000 a year, plus 130% of whatever the median income is for the area. If I'm a high earner, then you can introduce evidence, but you can't demand it. In other words, when you took the application and I filed my application and I said I made $125,000 a year, blah, 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 and I gave you whatever proof you required, you can use that information to dispel the fact that I don't qualify or I qualify. But as far as my declaration that I am COVID related, the legislature said at least until February the 1st, there is no rebuttal to that declaration. You, on the other hand, have to dot every I and cross every T. Okay?
So as a follow-up to that, if a tenant owes rent for, let's.
This is hard, by the way. This is hard. I feel like I'm taking my PhD exam. Go ahead.
Well, you're doing well.
You're doing very well.
If a tenant owes rent, then let's take this last half where an owner, they're supposed to pay the 25%. Do we need to serve that 15-day notice for each and every month, or should we just wait until January and serve the notice showing each month they're late?
If it were up to me and my tenant and my landlord wasn't pushing me, I would wait until February 1st.
Okay.
Because by then, there's a couple of things. First of all, Walter's monitoring the legislature, him and Gene and Adam. And we're going to know probably in December or January if they intend to extend 3088 beyond the current sunset date, which is February 1st. Okay. If I were a betting man, I'd run down to Pachanga and put money on extension. Okay. Just take a look at what's in the newspapers. You can figure it out. There are now more tenant voters than there are landlord voters. And so I suspect that you're going to see an extension. But as of today, I would wait until February the 1st. Then you're going to know how much is owed. You're going to be able to figure out what you're going to do. Again, you're going to have so many choices because if they don't extend, let's just say they don't. Come February the 1st, if I don't pay the rent, now you have a right to evict on current unpaid rent back to the old statute. So again, you're going to be making with the unlawful detainer lawyer or your personal lawyer or whoever, you're going to be making a lot of you being you or your owner, a lot of strategic decisions on what's the best approach to take on a case-by-case basis. If it's a single family residence and I own 2 or 3 rentals, that's one issue, right? I'm going to make a decision based on what's best for me with those 2 or 3 rentals. If it's a tenant who's acting in good faith, legitimately has problems, that's another issue. Again, and then there's always that 10%, you're the lucky winner and you got the bad tenant who's just taking advantage of the situation. Personally, and this is an issue for another day, people like me who invest, I took all my money out of California. It's all in another state. That is a little more friendly to people that work and have these issues. That's just me. You know, a lot of people still are not doing that. Anyway, so I personally would wait, but again, you have to make a decision based on what your owner's telling you to do, and also based on the realities of is that tenant even ever going to be good for the money?
Ron, I have a question based on your explanation.
Okay, go ahead.
So you said for the high earner, I could prove that a tenant was a high earner. So I served all the notices. They returned the declaration with just a typed letter that stated that they couldn't pay due to COVID, but no proof.
I don't know that they need to provide proof. They just need to provide proof that they're a high earner, and then there's some exemptions that can kick in, which I can go over with you. The issue, though, is that first of all, it's probably still not going to be able to evict for non-payment of rent. That's number one. Number two is, that's number one and number two. I guess most likely you're not going to be able to evict for non-payment of rent. They've taken out of the 15 different categories for being able to evict non-payment of rent from March the 1st to January 31st of next year. And if there's a COVID related incident, the other thing is, even though both DRE and CAR have come up with declarations that are forms that you should send, there is nothing in the statute that specifically says you've got to use either the DRE and or the CAR form. If I simply state to you that I'm not paying rent because my childcare expenses went up due to the fact that the schools are closed and blah, 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 or whatever it is, there's 6 different categories. If I say that, that's going to be good enough. And under the statute, even if I don't respond within 15 days, you can commence the action, but there's a curative provision in the statute that allows the tenant to file a late declaration. So again, all these have to be thought through, and I'm sure, I'm hoping, I haven't really talked to any of the eviction lawyers because that's not the world I travel in, but I'm hoping they're keeping up and developing strategies for you guys, and some of the bigger firms are coming up with news articles and letters. I know CAR has a couple of things that they put out. So it's going to be all about strategy. I get questions all the time about not letting you in for repairs. Totally unrelated to COVID, right? If there's a repair that needs to be made, you give the proper notice and follow the provisions of the statute. But in talking to the Department of Fair Housing, basically they've taken the position, if the tenant says, I'm afraid of COVID, you probably are going to have to figure out what you need to do. If the repair is something that's going to damage the property, a mold issue, something like that, probably can bypass the tenant and just warn them, here's your PEAD form, you should leave the premises, we're sending in the handyman. If it's something that's not related to habitability, then you need to make the call. But technically speaking, repairs are not necessarily and are actually possibly breaches of the lease that could lead to an eviction. So you ought to be having that kind of conversation with your tenant. And I don't know what the courts are going to do with all this. Obviously, it depends. You guys are lucky that most of your cases are going to be in French Valley, and the judges over there while they're not conservative, are certainly not like some of the judges we see up in Santa Monica or some of those areas. So, you might get lucky enough to have a judge saying, you're being unreasonable, Mr. Tenant. This landlord bent over backwards and, granting you the writ of possession. I'm looking at the questions here. Are there any other questions? Rather than trying to read all these questions, can you just ask them? Michelle, you had a question. I just got liability insurance policy from, okay, that's just information you gave to somebody. Anybody have a question they want to ask before I move on to the pre-printed questions? Somebody asked me a question about a fire that I want to answer. Maybe any questions?
I have a question real quick.
Yes, sir.
So I've got a very difficult tenant. He's even to get a text message back from this guy is like a miracle. He's a couple months behind on rent and the owner wants to sell the property. But this tenant is not going to be cooperative about letting us in to show. And I know, unless you have an offer, that I don't know how we're going to get an offer if we can't get in to show the property. As far as posting notices, 24-hour notice to show the property with COVID, we feel kind of like our hands are just tied.
Well, you want the good news or the bad news? There is no good news.
No, I knew that.
The fact is that NAR just issued a statement that, property managers are now number 2 on the list of the most likely people to get sued because of fair housing audits and now all of this. You've got a lot of problems there with selling a house, but I know people are doing it. I'm not a realtor. I'm just a lawyer. I don't sell real estate, but I've talked to some people there. The market is still pretty good. People are still willing to jump in and take the risk. This is going to end eventually, et cetera, et cetera, et cetera. It's going to be a different kind of buyer, I suspect, although I have no information to back that up. But yeah, if you're selling to a investor who intends to continue to rent, that difficult tenant is probably going to be able to figure ways to stay in, particularly for not payment of rent through January 31st, at least, the 75% part. You've got disclosures you have to make, that. If you're selling to a buyer and it's a residential 1 to 4, you're going to have to do a TDS, you're going to have to fill out an SPQ, and you're going to have to disclose the existence of the problems that you have with the house, because the statute says the property and or the transaction. So you have to disclose all material facts. So yeah, I agree with you, Michael. It's going to be tough, but there are people doing it. And so, it's not impossible to do. I personally would not buy a property, but then I'm lazy. I like the idea of just getting a check every month without having to jump through. Now, in Tennessee, we had a moratorium. It ended in June, and it was different than the moratorium that's here. But, states recognized, what was going on. People, they didn't want to spike homelessness. And that's really, at the end of the day, what this is supposedly all about, is if you kick somebody out, they probably have no place to go. And we're going to see a spike in homelessness. California already leads the nation in homelessness. And so that was one of the thoughts. But again, is that really true of a property that's being rented out for $5,000 a month?
The other question, when I think Dana was talking about the notice for the 25%, my understanding is tenants have to pay 25% of the rent for this period, but they don't have to pay any of it until January.
Yeah,
As long as 25% is paid by the end of January. Is it have to be 25% per month?
If I have a 25% of the rent, say, is $500 a month, $2,000 rent, commencing on September the 1st, I owe you $500 a month, which I have to pay you no later than January 31st of next year for it to become delinquent. If I don't do that, then I can be evicted. You can get possession after January 31st by filing a lawsuit for eviction. You're going to probably face some of the same issues Michelle is talking about. If the tenant files an answer, and as you know, under California law now, they can ask for a jury trial. You're probably looking at summertime. Probably. Again, who knows what the courts are going to do? Some courts may set up separate types of, hearings to take into account all of the different gluts of cases, and some may simply treat you like any other jury trial. But tenants are going to be entitled to a jury trial. You know that. And
When
so
did that start?
this year, I used to joke, it's a terrible joke, Sylvia knows I don't mean it, that I could probably make a fortune being on the other side of the table, simply because there's so many things that a lawyer that really knows what they're doing can pull out of their quiver. Right now, I would much rather be a tenant lawyer than a landlord lawyer. You got PAGA issues, you've got fair housing issues, you've got, and then we haven't talked about fair housing. We're simply talking about 3088. You've got all the other fair housing issues you've got to deal with now. So it's a tough road to hoe.
Hey, John.
No, there is no legislation. Let me just answer one quick question. I am not aware of any legislation coming, maybe Walter is, that would help landlords at all. There is some language in 3088 that extended the homeowner's bill of rights, and there's also some federal law for forbearance, but other than that, really not much. And again, you've got to be an individual owning less than 4 units and fit the other criteria. If it's a corporate owner or an LLC that has a corporate partner, there's really no help for you that I'm aware of. So just be aware of that.
I have a question, John.
Okay.
Hello.
Candace
I'm
first, and
just
then
going to
Dan.
ask a question. Okay.
Somebody.
All right.
David.
Let me go for Jessica Randolph. Her question was, I have tenants, and it's on the chat too, Jessica Randolph. I have tenants that pay a portion of rent monthly. Tenants pay in November half of the rent. Do we apply to November, or should we apply to April's rent? We want to clarify the 15-day notice when presented to the courts. We want to make sure how the courts will view payment and when they were made.
Well, again, I don't have a crystal ball. I suspect if the courts follow the law and don't fudge on, interpretation of the law, you would give notice the same way you would always give. If a tenant's 2 months behind, you give the one notice indicating that the tenant's 2 months behind. But keep in mind, if it's the 25%, first of all, if it's COVID related, I don't have to pay anything. I didn't have to pay anything, and I don't really owe you the 25% until January 31st. So there is a form. All of you are familiar with the 12 forms, I assume by now, that SRCAR came out with, and there is a form that allows you to do a calculation and come up with an actual number of past due. And they're telling you, do not include late fees or interest or any, just pure rent. And again, what I'm seeing from the clients that I have is they're simply taking a very proactive, let's negotiate something. And that seems to be working pretty well. At the very, very beginning, I had a client that she's not a property manager. She manages her own property. She's a realtor. And she just went to, we talked through it, and based on what we knew at the time, she went to all of her tenants and negotiated what it cost her to carry the property so that she wouldn't have to dig in out of pocket. She ate what her profit was and learned to live on without that money. And she's been doing that since March and February. So, again, it just depends on how you want to treat it. Let me give you a couple of pieces of advice, just as I've seen it over the last 8 months. First of all, none of us thought this would last 8 months, and looks like it's going to last probably at least another 6 or longer. Number one, and this is not for you guys, but if you have friends who are going, ooh, I think I'm going to get in the property management business, tell them don't. Now is not the time for amateurs in your business. The good news for you guys is aren't going to see too many new people coming in and crowding out your field. And then number two is don't treat this in an adversarial way. Yeah, you got bad tenants. I mean, you can't believe the stuff I'm hearing, just from the brokerage and from the defense side. Yeah, there's going to be people out there that are gaming the system. We all know that. Just do as much as you can, because at the end of the day, all you're going to be able to do is go to small claims court and, and get a judgment. At the end of the day, if it's COVID related, and pretty much everything's going to be COVID related, you're going to get a judgment. It's going to be a money judgment. So really, what's the key here? It seems to me, and I'm not a property manager, I have a very good property manager in Nashville, and I let them do their jobs. And every now and then they'll ask me a question, and I'll say, "What do you think?" But the real issue to me is possession. What can you do to try and gain possession if that's best for your client? And what can you offer? How can you work it out? What CAR is saying, and I am talking to Robert, and I did a panel with him a couple weeks ago, get possession. Do what you can to get possession, because if you've done an analysis and you've come to the realization that this is a judgment-proof tenant, then why are you fighting money, right? You're never going to see a dime of it anyway. Do what you can to get your client possession. And that may be cash for keys. That may be saying, you know what? I forgive all the past due rent, get out. And if you get out, rent's forgiven. Those are the kinds of things you're going to have to consider when you go through these things on a case-by-case basis.
John?
Yeah, go ahead.
On the situation with your friend who agreed to a certain amount of rent, can they then go back though at the end of this and get a money judgment, or was because they agreed to a certain amount of rent, that's it?
Yeah, if you have an agreement, you're going to pay 1,000 of the 3 per month times the number of months, or you're going to do this, whatever the agreement is, it's a standard breach of contract. That's the bottom line. There's going to be, again, we're going to be sorting a lot of this stuff out well into next year. On the sales side, as you can imagine, we're going to be sorting out all kinds of issues regarding impossibility of performance, breach, all kinds of deposit issues, and all kinds of fun stuff. But for your perspective, if you have an agreement, and the agreement's been breached, and you got back possession and then they don't pay you, yeah, you're going to go to court. I don't know in that circumstance, if it's over 10,000, whether you could still go to small claims. I think small claims is only going to be for unpaid rent, not for breach of contract. So I would suspect, you'll have to sort that out with your lawyer, but I suspect probably gonna have to file a regular claim if it's over $10,000. And if you put an attorney's fees clause in your contract, you might be able to get attorney's fees. Again, only if, again, as a lawyer, we counsel clients, and this is true across the board. If the defendant has no money, what's the other reason for suing them, right? If the client, all you're doing is, frankly, making me more money. I'm good with that. Don't get me wrong. But the reality is, it's not necessarily a good business decision to sue somebody who's judgment proof. It just doesn't make any sense to me. Of course, you've got to do your due diligence to make sure they really are judgment proof, but assuming that they are, then, and judgment proof doesn't just mean I don't have any money. I may have a job, but if I have enough exemptions because of childcare, other quote necessities of life where I can get an exemption, you're not going to be able to collect very much anyway. You may, get very little money. So,
John, this is Walter.
Go ahead.
I have an NAR meeting starting in about 5 minutes, so I'm going to have to leave. But according to the courts, February the 1st, they're going to be bogged down with everybody.
They're already bogged down.
Yeah. So February the 1st is not going to be a silver bullet for anyone.
I suspect that on February 1st, a bunch of things are going to happen. Number one, the courts are going to throw up their hands and go, holy crap, are you kidding us? You want us to litigate all these cases? If I'm a legal aid attorney or a tenants attorney or some other type of a group attorney, I'm filing lawsuits asking or filing answers and demanding jury trials. It's going to push it off even further. So there's that. Then there's the real possibility that this legislature will extend, the February deadline, even further down the road. They may modify the statute and provide some relief for landlords. They may not. They may strengthen the declaration issue, or they may do nothing except extend it into June. Who knows? Who knows what they're going to do? It's not a good time. It's not a good time. I didn't move my money out of California because of COVID. I moved it out because of rent control, because I saw that coming last year. So I just got an extra, I don't know, bonus because of COVID. So it's tough. I agree with you, Walter. I think February 1st is not going to be a nirvana kind of a day. I think it's going to be, we're going to know in January what this legislature is going to do, or what the governor is going to request it to do.
Yeah. So we'll just keep in touch and watch the bills that come. They won't be introduced until January anyway. So we'll just keep everybody informed.
Yeah, I think that frankly, from my perspective, if I'm doing any kind of real estate work right now, being a member of a realtor association, particularly one like yours, because I represent 8 of them, is really a good deal for my money, because I get all the CAR stuff, I get all the seminars, I get a lot of stuff, but you got to read it. Those forms are complicated. They're not that easy because the law is complicated. Again, this is my personal opinion. I read all 36 pages more than once, and I'm still confused about some of the stuff that's in that statute. So let's see here. What happens if you sell the property and the tenant does not want to leave? Well, if you've sold the property to a person who's intending to occupy, and that is legitimate, then you will go through an eviction process, period. And it will be an eviction not based on rent. It will be an eviction based upon the expiration of a duly served notice to evict, and then you will move forward. And of course, I suspect that the tenant will set up a request for a jury trial, and you'll do whatever you have to do. That's why if you're selling real estate, you ought to be taking into account in your negotiations lots of escape clauses and lots of extension agreements, because if you, this idea, well, let's do a 45-day escrow, that's really dumb, because you're not going to get it. First of all, if I enter into escrow today with Deborah, and she intends to occupy the property I'm selling her, and I have to give a 60-day notice, and I've entered into a 45-day escrow, basically Deborah just agreed to assume my unlawful detainer, or we've already got ourselves a default ready to happen. So you guys have to think through a lot of this stuff. The good news is realtors are worth more than they've ever been worth before to a seller or a buyer of property, because you guys are the guides through this process. So I've answered. I think I had a question about a fire that I thought was kind of fun. Fun for me, not necessarily for the person that had the fire. Let me see if I can find it real quick. All right. Okay, I'll answer this one first. I have a tenant who did not pay his rent for 2 months, April and May. He lost his wife, did not have a job, so he couldn't pay. So it was unrelated to COVID, but he used COVID as a reason. We executed a payment plan for deferred rent for 1 year with no interest. And now he has not been paying for the last 4 months, but skipped this month. Can I send a default letter? You can. That came from Ellen. I don't know if she's on there. I can see she's here, but she's not got her camera operating. I don't know the answer to that question. I would have to say, based on what I'm hearing here, since the tenant doesn't need to give you a reason, he can claim COVID. And again, what are you supposed to? I find this very abhorrent. The first time in 40 years of practicing law where the legislature has said you can file a false declaration and the person that you file it with can't do a thing to prove it's false. I find that to be absolutely unbelievable. So that's my 2 cents worth. But I You can probably sue them for breach of contract. Again, I don't know if the judge, here's the question, and I'm gonna try and have an answer by I just got this morning. I'm gonna try and get an answer by Thursday, because I find, here's the question. On the one hand, I have an agreement, right? Deborah and I have worked out an agreement. This is our deal. Deferred rent, blah, blah, blah. If I don't pay you, you can move to evict me. Are the judges going to buy that and evict on the grounds of a breach of contract? And if so, is that an unlawful detainer or a suit for an ejectment, right? And I know I've had that conversation with Bloom already about suits and ejectment, which is something you guys don't normally have to do. Or is the tenant going to be able to say 3088 overrides whatever we did, and because it's COVID related, you can't evict me for non-payment of rent, so long as it was COVID related between March 1st and January 31st? That's the question I'll try to have an answer for by Thursday. I think it's an interesting question. I don't know if you guys have opinions, if you've seen it happen. I would tend to think that if 3088 went into effect after your agreement was signed, it probably overrides your agreement. That's my personal opinion, because again, you go back to public policy and what was the motivation, what was the reason for 3088? It was clearly to protect tenants during COVID. Again, I believe that's going to be the answer to your question. The other question I got also this morning, I have a tenant who set a fire at the house, which was caused by lighting a candle. Okay, the dining room floor got burnt, and tenants want me to replace the flooring. And since the dining room, living room, kitchen, and family room are all connected, I will need to replace those areas. I informed them that I will schedule a flooring contractor to get a price that per contract, any repairs caused by tenants shall be charged to them. They're upset and said she was trying to save the house and was refusing to pay. What should I do? Sit down with your lawyer and go through these facts. Okay. This is again, these are easy questions to write, tough questions to answer. First of all, keep in mind that regardless of the reason, if you can no longer evict a tenant because you have to make, remember under 1482, the rent control law, one of the grounds for removing a tenant and paying a relocation fee was you're going to remodel the house and they need to leave. That particular cause has been delayed till February. You can no longer do that. The only reason you can evict a tenant or remove a tenant is if you have to make the house habitable. So if this house is no longer habitable because of the fire damage, it's conceivable you could remove the tenant. As far as who's to pay, have to look at the language of the lease. Are they judgment proof, et cetera, et cetera. Probably this question, you probably might be able to evict if a judge believes that the fire damage made the house uninhabitable. Okay, that's going to be again a question that's going to have to be raised and decided at trial. The other question that cropped up when I read this early this morning, Sylvia, by the way, comes to work very early because I got these questions at about 7 something in the morning. The other question I have, of course, is can you evict a tenant because of these kinds of damages? And again, the answer is very possibly, depending on the language of the lease, if they refuse to pay. Again, that's not rent. Again, you have to remember it's not rent. You have to really compartmentalize yourself. That's why I make the comment, this is not the time for amateurs to get into property management, because you guys have sort of the history of how these things really work in the marketplace. And so you're going to have to decide, I'm suing you, I'm evicting you because you damaged the property. Again, whether they did it intentionally or not. And then of course, the last question that comes up all the time is what happens if they won't let these service people in to make the estimates and do the repairs. That goes back to the talk we had before about, them not allowing people to enter. You have to make sure you use the PEAD forms correctly and all of that. So that's kind of where we're at. I see you've got, let's see. Yes, if you'd told me, okay, these are comments. I don't see questions here. John, we don't know what lawsuits are going to look like yet, but wondering what you think some of the cases may be based on from what you know now for landlords. Are you asking me, Jack, whether what I think the cases are going to look like that landlords are going to file, or cases that I think are going to look like for tenants to file, or both? I don't, there's Jack there. Unmute yourself. Which one are you asking me? Okay. Jack's taking a nap. So let me see if I can.
Working?
Okay, there you are. Go ahead, Jack.
Okay, hi. So I'm asking based on landlords, because several landlords are requesting us to do certain things that we feel that are going to be a liability. So I'm wondering what you think, based on what's happening now, what you think some of the lawsuits might look like against landlords.
I think, and again, I don't have a crystal ball, but in trying to look through, I've become sort of a reader between lines recently. I think you're going to see a lot of claims of retaliation where landlords are kicking tenants out and trying to use excuses other than rent. You're probably going to see some of those. Certainly breaches of 3088, arguing that landlords are not following the law correctly. One of the interesting issues that we're talking about again, I'm a member of a risk management group at CAR, and we're going to have a meeting actually next week, or week after next. Next week is Thanksgiving. Week after next is this whole issue of, when can someone sue because someone got sick in the house, or if I'm a tenant and you send over somebody and I get sick, what kind of lawsuits are those going to look like? The liability kinds of questions that are coming up. DRE just issued a notification that those realtors that are failing to follow the CDC guidelines are at risk to be brought up on DRE charges. So you're going to start seeing some of those citations and or accusations, which could lead to a loss or suspension of a license. So there's going to be let me just put it this way. Lawyers are not going to be really struggling to find work next year. I really feel that, from my perspective as a defense lawyer, because I don't sue realtors, we're just trying to figure out how to set up as many roadblocks for you guys as we possibly can. One of the reasons for the brown bag on Thursday is I want to talk about some other ways you guys can get in trouble. People are upset right now. A lot of you are very emotional, maybe not you guys individually, but your brethren are very emotional. We're seeing a lot of things that shouldn't be written in social media, about tenants. And if particularly if a tenant has a certain characteristic based on one of the protected categories, either race, ethnicity, color, gender identification, all that. Somebody puts something on Facebook about that. Let me give you an example, and I apologize, but I don't know how else to do it. One of my directors, not at your board, far away, was very upset with what was going on in his area. And he put something on his social media about that damn Muslim President Obama, right? Today, had he wrote that, he could be brought up on hate speech charges under the Code of Ethics. And that's what I'm going to talk about on Thursday. So there's just a lot going on right now. So I think that the lawsuits, I don't know. We're going to see lawsuits for breach of contract. We're going to see maybe some liability lawsuits. I talked to a friend of mine who's a plaintiff's attorney, one of the bad guys, and he was saying, it's going to be tough to prove these cases, because how do I prove I got sick in Dana's house, right? How do I prove that Candace really didn't adhere to the CDC guidelines? How am I going to prove that? But if I can, and I got sick, then maybe there's going to be liability claims coming out of that. What's that going to do to insurance? Those kinds of issues are cropping up. So I mean, I'm only 27 years old and look at me, I'm tired. I mean, we get up at 4:30 every morning and try to keep up on this stuff. It's just been tough. I know Sylvia's been working her tail off. It's just been really hard to try and keep up on a lot of this stuff. What's the good news? Can I give you any good news? Well, there's only going to be one new form come next month. So you don't have to worry about a lot of new forms. They're revising, and I'll go over all this on Thursday, but they're revising the contingency for sale of your buyer's property. But I'm going to tell you guys as property managers, you want to get real familiar with the contingencies relating to what the seller's going to want to put in there. You know, we've never really had a contingency for the removal of a tenant, right? I don't think there's a form for that. I'm not, maybe there is, I'm just not aware of it. But you know, there's going to be, you guys are going to have to think through, if you get the sale of your client's property with a tenant in it, you got to think through how that's going to look. Because if it's a bad tenant, what Michael said before is absolutely correct. You're going to have to deal with the fact that I'm buying a property with a bad tenant in it, and I may not be able to remove that tenant for a very long time. On the other hand, if it's a good tenant, then you want to be careful how you make that disclosure. So the other thing is they've delayed the new RPA until December of next year. So you don't have to worry about the new 16-page RPA. That will come out in December of next year. But I couldn't leave it with just good news. They're also going to be amending all of the forms that go with it. So in addition to the new RPA, there will be 50 to 60 new and revised forms to go along with it. But you don't have to worry about that till August. So we'll end the pandemic in August, and then we'll jump right into the new RPA for you. So by then I'll be in Nashville, and I'll be doing this remotely. And then I'll go and I'll have moonshine readily available for those of you that want to make the trip.
I got one more. Going back to your conversation in regards to the 30-day notice under a sale, that can only be applied, and that notice can only be given under a month-to-month and not a term, right?
That's correct.
Okay.
Also, it only applies under certain circumstances. And so you can't really give the land. Here's where we start getting into this legislature not properly doing its job. A good legislature would write laws that are not inconsistent with other laws, right? So that you don't end up in a gotcha situation, okay? As I understand the 30, because I don't normally recommend a 30-day notice for a tenant that's been in the property for more than a year. By the way, this only applies to individuals. It doesn't apply to tenants who are corporations, LLCs, okay? Only applies to human beings. Does not apply to commercial. It does apply to mobile homes. So just, again, there's an applicability issue. But the 30-day notice, as I understand it, is a notice you can give to a tenant that the property is going on the market and is going to be going into escrow, right? Well, but you don't know if you can evict the tenant for that reason until you actually have an offer, right? And then I think you have to decide if you can give a 30 or a 60-day notice. Because if you don't have an offer from a tenant that intends to occupy, then eviction of a month-to-month tenant may not even be available to you. So
Thank you.
That's that. Any other questions? Again, remember, guys, that what this law essentially did is it removed non-payment of rent as grounds for eviction. There are, and it also suspended as grounds for eviction remodeling. Okay, so there are now 11 grounds for eviction. There were 15. Now there's 11. So you need to be clear on what those 11 are. If you fit within those categories, then you can evict. But again, don't be careful of that concept of waiver where you've allowed something to go along and now you're evicting. You know, maybe it's, I don't know, some kind of a nuisance or some kind of a violation of, and now because the tenant's not paying, now you're going to evict them because of the dog, which is the case we had recently, right? That situation, you got to be really careful, because if you are found guilty of retaliation, the fines can be up to $2,500 a day. Probably less. Not going to say that's going to be the case all the time. So probably less. Okay.
Thank you so
I'm
much,
sorry to ask
John.
again.
And
Okay.
we've hit 10 o'clock. We do have our MLS task force following this meeting. So I guess we'll continue this conversation on Thursday with our brown bag. That one is scheduled, I think, for 2 hours. So we'll definitely have a little bit more time. And I put the link on the chat so that you guys can join us on Thursday as well.
Yeah, I hope I see some of you. You guys asked great questions. You really did. This is tough stuff. I think this is probably even more so than some of the other stuff that we're seeing. Since day one, landlord-tenant law has been the single most asked question, relating to all the different things we've talked about, and is the single most problematic. So the good news is you guys are more valuable than you've ever been, right? You really are. If you know what you're doing and you're not a Johnny come lately or a Janie come lately to this business, and you have some experience and you think through and keep your emotions under control, you're much more valuable than you've ever been, and you've always been valuable. So thank you, Sylvia, for setting this up and inviting me. I appreciate it. And I'll see some of you on Thursday at 1:30, not the normal time. So it's technically not a brown bag. And if you want, my email address, real quickly, my email address is jvg@Tyler, Tyler, Bursch, no space, just Tyler Bursch, BURSCH.com. Send me an email question preferably before noon on Thursday, and I will try to include it in my presentation. Okay. And then I'm going to try and save a half hour for more questions, but then, depending on how many people there are. All right. So thank you, Sylvia, and we'll see y'all next week.
Thank you, everyone.
Deborah, good to see you again.
Thank you, Sylvia.
Bye, kids.